How do we handle high liability requirements? What's the role of an insurance broker? What do I do when things go wrong? And then just the general understanding of what the insurance covers and specifically for museum and exhibit professionals. So I'm happy to jump into that in my presentation today. Um, so with that, we will get started on the first slide. So really, um, do I need insurance and what type? It Your need for insurance depends on what your business's exposures are. And when I say exposure, it means what you can be sued for, or what you could potentially have a financial loss for. So, for example, every business is a little bit different, especially within the Museum Professionals Association. So, if you give advice or if you give design work to others, then you have an errors and omissions risk, which we'll jump into that in a little bit. But and that's one example. If you don't ever visit a job site or a venue, you don't have a general liability risk. So again, it just depends on what your exposures are for each business. And I'm going to try to make this as easy to understand as possible, and we'll have Q&A after if you have any questions. But basically, the job of the insurance broker is to advise you on what coverages you do and do not apply to your business, and to help you with when you get these insurance requirements from clients or venues on to give you what you need to be able to negotiate with these people. Because a lot of times their requirements are going to be the same for all contractors they hire. Any contractor that comes on premises, they're going to require a $5 million umbrella, et cetera. So it's the job of the broker to help you through that process. So um, with that, the main types of insurance are going to be the E&O or professional liability. It's the same thing. If you ever hear professional liability, errors and omissions, they're the same thing. And what that covers is if you if you make mistakes, if you make an error or omission in your design services or professional services that cause a financial loss to a third party, that triggers the E&O coverage. And what the E&O covers is the cost to hire an attorney to defend you in a lawsuit, and it also covers the settlement costs to any victims if you're deemed liable. If it's a baseless claim that your business gets drawn into, the E&O would pay the cost to hire an attorney to help you get out of the lawsuit without you having to come out of pocket to pay for an attorney. And again, E&O is nothing to do with injury or property damage. It's a mistake, error, or omission in your professional work that causes a financial loss to a third party. So that's E&O. Now, general liability is basically if your business or someone you hire or something you create, manufacture, ends up causing somebody to get hurt or property damage, and that happens to a third party that's not your business, general liability covers that. And again, it's going to cover the cost to hire an attorney to defend you. It's going to pay the settlement cost to a victim if you're deemed liable, and then it's going to also help you to defend you if you get brought into a baseless lawsuit. So again, E&O professional services, general liability, injury or property damage. Workers' comp is if any owners or any employees get hurt while working at the job site, workers' comp will cover that. And we'll get into that in a second, but if you don't have any employees, if you're just an owner, a lot of times you are able to negotiate out the workers' comp requirement, and it's the job of the broker to recommend that, because you don't have any employees and the state that you're in is not going to most likely not going to require workers' comp coverage. And then just a few notes on the last three. You might see cyber liability. That's if your business has a loss from getting hacked. If you have personal information, some of this isn't going to apply to all the professionals here, but if you have personal information on clients, if your business gets hacked and demands a ransom, and they kidnap your systems and they're demanding you to pay money to get your systems back up and running, cyber would cover that. And then it also covers social engineering. If you get tricked into paying somebody, let's say you're paying a vendor, but they're a fraudulent criminal pretending to be a vendor, and you accidentally send them, thousands of dollars, cyber liability would pay the cost to get your money back. Umbrella is just going to give you higher limits on the general liability, and then property, inland marine, that's your stuff. So if you have an exhibit that you own, if you have business personal property, property, inland marine, and fine arts, those are all your stuff your business owns. Blair is going to go more in deep into fine arts in her presentation at another time, but those are some of the main coverages, and we can go to the next slide. So with that, some examples of general liability claims, for exhibit for your type of businesses. So my understanding is that you guys are exhibit designers, exhibit fabricators, actual museums, art handlers, exhibit planners, project managers, designers, installation. Maybe you hire out installation, storage, warehousing of exhibits, etc. So examples of general liability claims would be you're installing an exhibit, you're having an exhibit installed in a museum, a visitor trips over your tools or wiring, and they get hurt. They go to the hospital, they call a personal injury attorney, Morgan and Morgan, etc. And then you have a lawsuit that lands on your desk demanding $200,000. And you have to show up in court. General liability is going to pay the costs to defend you and show up in court for that. And another example would be if you hire a subcontractor to, install something and they accidentally cause damage to a display case or an artifact during the setup, damage to property of a third party, that would also be covered as well. And then if you were to host an event or manage an event, and somebody slip, trips, and falls, even if it's not your fault, if you're hosting the event, you can be brought into a lawsuit as well. And injuries, they depend, but they could end up being a lot of them end up being six-figure claims if it's a bad enough fall. And then one thing to note is for subcontractors, you could be held vicariously liable if they screw up. So not only if they cause property damage, but if they were to do something to cause an injury to somebody else, that's covered as well on general liability. And then moving to the next slide, the E&O coverage, exhibit design errors. So you design an exhibit layout and the flow doesn't work. If there's safety issues, accessibility issues, and the layout maybe causes poor visitor flow, if there's inaccurate content, or they deem it inappropriate or something like that, then the museum has a financial loss. They can sue you for that, for losing money, having a financial loss because of an exhibit design error there. Another thing that covers is the missed deadline. So if you were supposed to have delivered your design in a certain amount of time and you don't get it in time and they have a financial loss, they could sue for that. Incorrect interpretation, content issue could be another example. And then budget mismanagement. If you recommend vendors or oversee a project and costs overrun or the vendors fail, your decisions could cause financial damage. That's an E&O claim as well. And then lastly, scope misunderstanding. If a client expected something different than was delivered, that leads to a dispute or demand for reimbursement, E&O would cover that as well. And yep. And then, so moving on to this slide for insurance requirements. So we always recommend that, first of all, we'll talk through with you over the phone, if you're a client of ours, okay, here are the insurance requirements. Are these reasonable or not? If they're not, and do they apply to your business or not? So even if they do apply to your business, even if they are reasonable, we still, if you would like to push back, we recommend that the worst that the client or the venue can do is say no. But we can give you, or your commercial insurance broker can give you what you need to go back and in actual writing to go back to the venue or client, say, no, actually my work is remote. So we don't visit the job site, so we shouldn't have this general liability requirement. Or what I'm doing, you're asking me for a $5 million umbrella on top of my 1 million general liability. What we're doing is so low hazard that it's an unreasonable ask for businesses like me. And you could say like, hey, my insurance broker works with other businesses, and this is a very unreasonable ask to ask for a $5 million umbrella. And it may make it where it's doesn't make sense for you to go ahead with this project, etc. But really, if you don't ever visit the job site, you should negotiate out general liability. If you don't have employees, you should work to negotiate out workers' comp. If it's a $5 million umbrella or $3 million umbrella, and what you're doing is very low hazard work, you're not hiring contractors to do a big job or big statue or something like that, then we highly recommend pushing back. The worst they can do is say no. And then at that point, once you get their answer, then you have to make the business decision of, do I go ahead with this or not? The insurance broker gets you the cost of what they're requiring, and then you know what you're going to make. So you have to do the cost benefit analysis, and that's not the job of the insurance broker to tell you go ahead with it. That's your job as the business owner to decide if it's worth it or not. But it's the job of the insurance broker to help you through these negotiations. So your insurance broker should review the contract, review the insurance requirements, recommend if there's something that's unreasonably being asked, and then also if there ever is a claim, to help you during the claims process. So with that, if a client asks you for more coverage, there's really three options. You can negotiate down, attempt to negotiate down. You can go with what they're asking for, or you can walk away. And it's our job to kind of help you through that process. And yeah, we can go to the next slide. So when things do go wrong, if something lands on your desk, a tender demand for payment because of an injury, you want to call your insurance broker right away. You want to submit the claim, even if it's not an injury. If it's just, hey, error in your design or issue with your design, we're suing you for financial loss. You want to let your insurance broker know right away. Your insurance broker will put in the claim and advise you through the process, and working with the claims adjusters. And we talked about what the insurance actually does. It pays for the legal defense attorneys, settlement costs, and it helps you get out of baseless lawsuits. So yeah, and is there another slide? Yeah, okay. And okay, so at the end of the day, in closing, like, you hope that you never have to use the insurance. It's there for that worst possible scenario, that worst possible day that can really threaten your business, that six-figure lawsuit that lands on your desk that can really drain your business in legal fees and also in potentially settlement costs. It's there for your worst day. You don't want to, you're not getting insurance to want to use it a lot and have a bunch of small claims. It's really there for the big losses. And it's not about, in closing, yeah, it's not about expecting something to go wrong. It's about making sure that one mistake or one claim doesn't take away everything you've built. And I think that's it. Is that the last slide? Okay, yeah, that's the last slide. And we'll do a Q&A after. Obviously, every business is different. So if you have any specific questions for your business, I'm happy to go through that.
Awesome. So thank you so much, Christian. Really great information. And just really quickly, we mentioned Blair Wunderlich. She is also an insurance expert specializing in fine art insurance. So for those of you who handle museum objects in your work, you might be interested in learning from Blair. Because she couldn't be here today, she has offered, first of all, to send us a handbook that we will forward out to all of you as a follow-up that will detail what you need to know around fine art insurance. And then also she has offered generously to host a separate webinar for IMP around fine art insurance. And so if that is something that you are interested in, go ahead and put yes in the chat. We're just going to kind of casually gauge interest here. And if it seems like something we want to go forward with, then we'll organize that with Blair and get back to you with more information. And then, yes, continue to put your interest in the chat if you'd like a fine arts insurance webinar, and we'll move forward with our next panelist.
Hello, everyone. My name is Sam Mazio. I am the attorney on the panel today, so I will be covering by far the most boring material. So, what I'm going to cover today, I'm going to kind of give you guys a little bit of a framework to start, and then we'll go through basically business entities, contract, and intellectual property. So, one of the things that I think is a helpful framework is something that I call the three lines of defense. And these are going to be the lines of defense against your personal liability anytime you're doing work or you're putting art out there. And these three lines of defense are not the only ways to protect yourself, but they are going to be kind of like the most foundational ways to protect yourself. I'll go back to my disclaimer here in a second. And the three lines of defense are essentially going to be a contract. So anytime money or services or art is exchanging hands, you should have some type of contract in place between those parties. That's going to be then the place where all of the expectations are set, also hopefully where any dispute resolution mechanisms are laid out. And so that's why that's going to be the first line of defense, because it's the first touch point with you and the other party. Now, people might say, well, I think you breached the contract, or I don't care about the contract, I'm going to sue you. The second line of defense is going to be insurance, which Christian was just discussing. And then, of course, with insurance, one of the sort of like notorious things is that they won't pay out on a policy that you have. Hopefully that doesn't happen to you, but if it does, then the last line of defense is going to be your business entity, usually an LLC or a corporation. And that sort of acts like the kind of end all be all backstop towards any of that personal liability. And all of this is designed to prevent like your personal savings, your home, your car, your personal assets from being subject to damages from whatever the business is that you do. So the entity itself would be the one that's liable and not you and your personal assets. Now, back to the disclaimer here on my title slide. As an attorney, anything that I'm sharing today is not legal advice for you specifically. I don't know your facts and circumstances precisely. So this is general advice. This is not legal advice. There's no attorney-client privilege or relationship formed by giving this advice, and you definitely should consult with an attorney on your specific facts and circumstances before acting on anything that I lay out here today. Well, that's my lordly duty on that. We can go to the next slide now. All right, so using that framework of the three lines of defense, these are going to be the types of ways that you can protect yourself with an entity. So these are going to be that backstop, that last line of defense. And it's important to kind of highlight here, though, that with a sole proprietorship, so anytime you go out and do business without an LLC or a corporation, you're going to be considered a sole proprietorship. And with a sole proprietorship, you don't have any of that personal liability protection because it's just you doing business. So all of your personal assets are subject to any damages, risk, or liability for the work that you're doing. Now, if we go to an LLC or a corporation, those are going to be the types of business entities that do provide personal liability protection. The way you can kind of think about this is that with an LLC and a corporation, you do have to file with the state. There are going to typically be separate tax filings. You need a separate bank account. You would need an EIN for your LLC or your corporation. And all of those administrative sort of hassles or duties or tasks, you can think about those as the trade-off for your liability protection. You have to file with the state, you have to get an EIN, you have to have a separate bank account, you have to usually have separate tax filings. And in exchange for all of that hassle, you get the personal liability protection for anything that comes up while you're doing your work. And you can see here, I have a note. It's essentially like the business, that LLC or that corporation is a separate legal person from you. And if you think about it that way, it is helpful, I think, in the legal world to think about your business as its own legal person. It can buy things, it can sue, it can be sued, it can have bank accounts, it can get debt. It has a lot of the same things that a person would. And the EIN, you can think of it just like a social security number, but for your business. Now, the next note down here, the corporate veil, that's really what helps to maintain that liability protection that that LLC or corporation gives you. And what this means is some of the things I mentioned, separate bank accounts, making sure you're paying your taxes, any state, local, city filings, you have to be making those. Don't mix your personal funds with your business funds. That's why there's the separate bank account. Just making sure that you're doing everything that you're required to do for the business and keeping it as separate as possible from you personally. That's what helps it be that separate legal person. And that's what creates what I have here, the veil. The corporate veil you can think of as like a shield against your personal liability. And if you aren't doing those things, it allows someone to potentially pierce the corporate veil and sue you personally. And you can see here the note at the bottom. It's pretty quick and easy most of the time to set up an LLC or corporation. There might be legal fees. You got to pay an attorney typically to set these things up correctly. But that upfront cost typically is well worth the protection and the peace of mind that you get. And so again, to quickly recap these, sole proprietorship, no personal liability protection, that's just you. LLC or corporation, as long as you're keeping things separate, like bank account, making your filings, have your EIN, as long as you're doing those things with your LLC or corporation, it should protect you against personal liability. All right, I think we can go to the next slide. So now we're going to talk about contracts. So this one was the one that's going to be that first line of defense that we talked about. And it's always really important to consider that when you're doing any type of business and somebody gives you their contract, like I have here, if it's an institution you're working with, that contract is drafted for them. That's not drafted for you. So that means it's going to be much more beneficial and help them more than you. So it's really important always to read your contract, make sure you're negotiating it before you sign it. If there's anything in there that you don't feel is appropriate or is even maybe negative for you, because that's usually the push and pull of contract negotiations is this is better for me, but maybe worse for them. And you have to go back and find a mutual compromise there, assuming that they're willing to negotiate with you. Sometimes larger institutions are kind of a take it or leave it type of thing. And then it becomes a question of, are these terms reasonable enough for me to take this? And I think the tough thing always is we need the work, especially with artists. You need the exposure, you need the money. And sometimes it's hard to turn something down, even though it might not be super favorable to you in the contract. And I don't ever tell my clients, yes, do that, or no, don't do that. But I explain to them how much friction they might face or how unfavorable a situation might become if the contract is really sort of draconian and against their interests. And ultimately, it's up to them whether to move forward with it. Now, the second point here, Christian touched on this a little bit with the insurance policies. You can limit your indemnification to anything that you actually caused. And so indemnification is just a fancy lawyer word that says if I create some liability and you're sued for it, I have to defend that because it wasn't your fault. So it's my responsibility to handle that. And indemnification factors in with insurance sometimes because if you think about it, insurance is essentially there to make sure that if I do something, the other party I'm in contract with doesn't have to foot the bill for that or be held liable for that. So the idea is that if you do something and your insurance policy pays out, it prevents you or that other party from having to pay out and be liable for that. Now, if you end up in a situation, I think Christian touched on this as well, where let's say the insurance policies that they're asking you for are way outside of your price range. You can't even afford to get those policies, but they are requiring them. One way you might be able to negotiate that is say, all right, how about instead of having to get that really high policy that I can't afford? And then that might allow them to say, okay, that's sort of the same end result. You're promising in this contract that you'll handle whatever comes up under the indemnification. And then that's your responsibility. You may not have the insurance to pay for it, but you're promising to handle it. And that's the rub for you is if you can't afford the higher insurance policy, but you increase your indemnification to handle that liability, you may then be stuck trying to make that difference work because you don't have the insurance payout, but you promise to handle that extra liability. So there could be a bad end result to that, but that's assuming that nothing ever actually comes up and you don't actually have to take care of any of that liability, which is also, the hope with insurance as well. So kind of confusing, just to reiterate this, you can negotiate a higher indemnification where you handle liability you create instead of having higher insurance policies that you can't afford to get at the time. The next note down here talks about force majeure, sometimes called acts of God. These are types of things where if something comes up that's beyond your control and you can't perform the agreement, this provision will give you a little bit of a breather. It'll allow you some time to maybe figure out another way to satisfy the performance, or perhaps allow you to cancel the contract because it's just no longer feasible. These obviously came up a lot during the pandemic. It was a situation where if you didn't have this provision in your contract, you were in a pretty bad place because it didn't provide any type of out for that situation where, let's say it's a wedding venue, and obviously you couldn't have a wedding at the height of the pandemic because of people gathering. So if you didn't have that in your contract as a event venue, you were stuck canceling the contract language in your contract that said you could get out of this if it's outside of your control. So super important provision to have, especially in situations where things are in person, where you have to deliver. With the way our kind of mail and our transits going these days, you might want to have that in there in case there's some kind of huge delay going on. I'm supposed to fly out tomorrow and I'm worried whether or not I'm going to be able to do that. So these types of provisions, when it's something out of your control, can be very helpful. Now, subcontracting is an interesting thing for a couple of reasons. One is that I have seen a big increase in larger institution contracts saying, we want to have oversight over and approve your subcontractors. Meaning that if you have people that you subcontract out to, you have to share information about them. They may even have to be interviewed by who you're contracting with. And if who you're contracting with doesn't like them, they might say, no, you can't hire that person. To me, that's a little bit too much of them getting over on your side of the fence when it comes to your operations. And your contractors should be yours and you should be able to trust them and they trust you. But this is something that I've seen a lot more recently. So that can be something that factors in, and whether or not you want that oversight is a question for you, but it can cause additional liability if you have a contractor that they don't like and then they said you shouldn't have them, but you worked with them anyway. You might be in breach of contract. The second reason I said there's a couple of reasons is that independent contractor rules are changing a lot, and they are somewhat more difficult to satisfy nowadays, especially in a state like California, where I am. So if you have subcontracting restrictions in your agreement, and specifically if the agreement says you have to abide by all laws and rules and regulations where you are, and let's say inadvertently you don't even realize that you're out of compliance with independent contractor laws, you could be in breach of contract because you're not satisfying that law. And most of the time when I talk to people, they're not even aware that the subcontracting laws have changed. And so they think that they are in compliance when in reality they are not. And in California, again, I'll stress this, California, it's very difficult to classify someone as a contractor these days. The creative industries, it's a little bit easier because of some lobbying exemptions from the new law, but AB 5 and AB 2257 in California have made contracting very difficult. So it's worth taking a look at that if there is any type of language in your contract with someone about subcontracting. All right, next slide. So now we'll get into the intellectual property a little bit with how these look in your contracts. So I always like to kind of create this framework with these where a license for intellectual property is kind of like a lease, like if you think of a lease with a car, and assignment is more like sale and ownership of a car. So the idea here is that with a license, you're granting permission to use whatever IP you created within certain parameters. And you actually retain all ownership to that intellectual property. I mean, you can do with it whatever you want. There's no parameters on your use of that intellectual property, but you gave permission to your client or your partner to use it within specific parameters. This is where it's like the lease of a vehicle, where if you lease a new car, you have a certain mileage limit for the year. You know, you can't do certain things to it because you don't own it. It's just yours to borrow essentially based on the parameters of that lease. So you might get it for 3 years and you have to do less than 10,000 miles a year. That's kind of like an intellectual property license where maybe it's you can use this for one website for 1 year and you can't sub-license this to anyone else. So that's where you can see lease of a car, license of intellectual property. They're kind of similar. Similarly, with an assignment of ownership of intellectual property is more like a sale because you are actually giving up all of your ownership rights. So the same with if you buy a car, you can do with that car whatever you want. You can paint it, you can change it, you can drive it as much as you want, no limits. Same with intellectual property. If you're given ownership of IP, that's yours to use on as many websites or billboards or bench seats or products, whatever that might look like. That's up to you because you own it. And then who created it and gives you that assignment of ownership no longer has any rights to that intellectual property whatsoever. It's not theirs anymore. They can't use it. They can't control how you use it. The only exception is if there's a license given back to the creator to display it for their portfolio or something along those lines. And then that's going to be another license. So similar to the license as I explained it, but in reverse to the creator since they gave ownership instead of a license. Now, under an assignment, that's where I was just touching on is if you assign ownership, but you want to display that work in your portfolio just to show what you've worked on, you would need to have that license back to you and permission from them because they own it now. And then a quick note here on this type of language, a lot of the time you're going to see work made for hire or work for hire. That can actually be a little bit dangerous these days because work made for hire times can essentially transform an agreement into an employment agreement, at least under the new California rules with independent contractors. So my recommendation always is to have assignment language or transfer all right, title, and interest instead of work for hire. That's usually more of a problem for the party that's engaging you and would be considered to employ you if they have this language. And there's other factors at play, but if there's work made for hire language, it can be one of several factors that ultimately can result in sort of inadvertent employment status, which typically nobody wants in these scenarios. So it's something to look out for. And then last slide for me. So this is just some important notes when it comes to intellectual property ownership. I think it's easy to get confused with this stuff because it's a little bit nebulous and it's not sort of concrete. And so a lot of the time you'll see on this first one, people might think that physical ownership of something means that they have the intellectual property rights ownership. And that's not always necessarily true. You may have physical sort of possession of a sculpture, for instance, but the artist may have only given you a license to display it. They may have retained rights to the images of that sculpture. They may have retained the rights to file copyright for it. So just possessing something doesn't automatically mean ownership when it comes to intellectual property. And then similarly, I would add something here that's not on the slides. So one thing that I see confusion on very often is that If, let's say, for instance, you take a video or a photograph and it has people in it, or it has an identifiable landmark, or even it has like trademarks and branding in it, if you don't have the rights to what's in that image or that video, even though you own the image or you own the video, you might not be able to display that image or that video if you don't own the rights to what's in it. And a lot of the time, that's going to be people. People have image and likeness rights and a right to privacy. And so if you just take a photo of someone and then you blow it up and you start selling it commercially, that person might be able to sue you because that's an invasion of their privacy. You're using their image and likeness without their permission, and you're doing it for a commercial purpose. So there are a lot of sort of layered rights when it comes to images and art, and especially photos and videos. And then we're going down here to the work for hire assignment, which I touched on briefly before. And you have to just make sure that with any type of intellectual property provision, that it's drafted well and it's very specific, because if you, let's say, give someone a license and you don't have very definite parameters on it, you just say that they get to use it for a certain period of time, you can end up in a situation where that's used in a whole bunch of ways that you didn't even contemplate. We've had clients give sort of open-ended licenses before for intellectual property that they expected to, let's say, only be used internally for the company they gave it to, but then they saw it on a car wrap or a bus stop bench or something along those lines. And a lot of the time with artists, you don't want to see your work in places that you don't feel like is appropriate or that does it justice. And so these are really important things to make sure that not only do you have this language in your contract, but that you make sure that it is dialed in and it is accurate. These types of things tend to happen when you're kind of like cobbling together an agreement from the internet, or a friend of yours says, "Oh, I've got an agreement and it's worked great for me." They may never have been tested on that agreement, and so you might not know what's actually in there. And so all of these things, super important. And the last note I'll give you guys here is that there's also always a little bit of a sort of missing link in contracts when you actually have to transport work or ship it, because there is a need to identify who's liable for that while shipping and while in transit. And usually what you want to do is that once it reaches the carrier, so, FedEx or whatever you're shipping it with, courier, that then the liability shifts to the recipient and it's no longer on you for any of that travel issues. They're going to push back and say it should be on you while it's shipped because you picked the shipping company. But that's just something to mention, that you should make sure that that's clear and sorted out before that stuff is in transit, in the event that something happens to it and you're scrambling or arguing over who's actually liable for that damage while it was in transit. And then generally, just kind of the note with that being the last note here is that it's a situation where you just want to make sure that anything and everything that is important is very clear, very dialed in, and laid out in the contract. Because again, it is your sort of like first touch point. It is the overall sort of roadmap and document, and what I like to call your sort of personal legislation between you and the other party. So it's important to make sure that you get everything in there that's going to cover everything that could come up for the situation. Similarly to insurance, that contract is all for the what ifs and to help you in that situation. So all very sort of proactive risk mitigation measures. I think that is my last slide.
All right, awesome. Thank you so much, Sam, and thank you again, Christian. We have some questions that have come in, so we will get right to answering those. I'm going to address the questions that are already in the chat, and then so if something comes up for you, drop it in the chat and we will add it to the list. So question 1. For those of us that prefer to remain sole proprietorships, what is the recommended insurance?
Yeah, that's a great question. So, I mean, Sam pointed it out. If you're a sole proprietorship, you know that you could be sued personally, right? So, the first place to start is, what are your personal assets? Like, how much do you have in investments? Your home, all the assets that you have under your personal name, that if something terribly went wrong and you're doing business under your personal name, they could sue you for all your personal assets. So if your personal assets are 300,000, you want to make sure you have at least 300,000 in limits. If they're higher, you don't want to have a coverage gap with that. But just know that they can sue you for more than your assets as well. That's a possibility, um, but in reality, you're going to want to start with what are my personal assets, and that's the limit that you should be looking at to start with. And if you have an E&O exposure, and a general liability, if you're going to the job site and you have, or to the venue or to the museum, and you have a design exposure, you want to make sure you have both E&O and general liability up to whatever that limit is if you're a sole proprietorship. Because otherwise, if something goes wrong and they sue you personally, then they can demand records on what are your investments, how much your home is worth, your car, all the things you own, and they can go after that. Does that answer the question?
All right.
And I would add to that too, just a real quick thing that I've learned in my work is that typically with these insurance policy limits, you have to take into account not just what the liability dollar amount might be, but also what you need to pay an attorney to help defend that suit. Because
Yeah.
I've seen situations where attorneys look at an insurance policy coverage and they say, that's too low. It's not going to pay our fees and the damages if you end up having to pay something here. And so you have to take into account that it's not just the damages, it's how much you have to pay lawyers on top of that.
Yeah.
And I'm not a big fan of lawyers just as a side because of things like that.
Yeah. And even if your personal assets are 300,000, if the medical injuries are more than 300,000, like if the injuries are 500,000 or the property damage, they could sue you for more than your personal assets. So that's another scenario of you don't want to just think about covering just your personal assets. You want to start there, but you also want to think about the attorney fees and then what they can potentially sue you for.
Exactly.
All right. Thank you. Okay, next question. My letter of agreement says Laura Roberts's liability for this contract will be limited to the professional fees. Is that adequate protection? And then a part B to that, Tamara says, as a subcontractor to a larger firm, I often run into a requirement that their contract terms regarding indemnity flow down to me with terms that seem overly broad for the scope of my work.
Mhm. So I'll touch a little bit on the insurance part, and I'm sure Sam will touch on the legal part. So the first question was about, remind me again, what was the first question?
It says, in Laura's agreement, her letter of agreement, it says that
Oh,
her
yeah, yeah.
liability for this contract will be limited to the professional fees. Is that
Yeah.
adequate?
So that's a really good thing to have in your contract. That's called a limitation of liability agreement or limitation of liability clause, which we recommend our clients put that into their contracts. And the reason is a lot of times they hold up in court where they can only sue you for that dollar amount. So whatever your professional services are on that, let's say you're only making $10,000 on this job, the contract says you can only be sued for $10,000. So actually insurance companies really like that as well because it limits their exposure of what they can be sued for. And a lot of insurance companies give significant discounts if you include limitation of liability agreement in 75% or 100% of your requirements. Now, not every venue and every client is going to accept a limitation of liability clause, but it can only help you. It can't hurt you. So we always recommend, and we always recommend clients work with an attorney to get that built into their contracts. And again, it limits it to the dollar amount of your service, not your whole insurance policy. So it's a really good thing from an insurance side and to limit your risk. Because at the end of the day, if the claim is only 10,000 and the loss was 100,000 and you have a good agreement, they a lot of times that holds up where they can only sue you for 10,000 and the rest they have to figure it out. So, and I'm sure Sam wants to speak on the legal side too.
Yeah, I would add to that that I probably wouldn't say that that's adequate just because for an attorney, the devil's in the details. And I would say, how are you defining professional fees? because that I think is a situation where my mind goes to, let's say there's some type of dispute and they want to argue that whatever damages they want to sue you for are professional fees. And if you didn't have that defined in the contract, you could then be stuck with more damages than what you expected it to be. So that's just a kind of general note on contracts is like any really important terms within the contract that you are like, oh, I wonder what that means, have it defined so that you know what it means. And then beyond that, yeah, limitation of liability provisions are excellent. Certainly should have those in all types of agreements. The one that I see most commonly is it's going to be limited to the fees that you were paid or the fees that you pay, depending on the role you play in that relationship. And that's usually pretty good because it essentially just means if something happens, the money goes back to where it came from, rather than it being something like Christian mentioned, where they're suing for 10 times the amount of the contract. So definitely good. And if it helps with insurance as well on those policy costs, that's obviously a double benefit. So certainly having limitation of liability in there is good, but making sure that it's clear, defined, and dialed in so you're not wondering what it's limited to based on the terminology. And then I think there was a second part to that question on contractors.
Oh yeah. Yeah. I think the second part was about indemnification. Jen, do you mind reading it again?
Yeah, it says, as a subcontractor to a larger firm, I often run into a requirement that their contract terms regarding indemnity flow down to me with terms that
Mhm.
seem overly broad for the scope of my work.
Yeah. Yeah, and Sam touched on this in his presentation. This is a situation where it depends on the type of client you're dealing with. If it's a big business with lawyers backing them, they're going to be very strict in almost like a shark way, where they're going to build their contract that only helps them and pushes all the liability down to you. And sometimes if you know that going in, you know the business risks, and you're getting paid X amount, and you decide as a business owner, okay, I know what the risks are. I know they're pushing it all down to me. If something goes wrong, I'm going to be held responsible, but it's a good opportunity for my career. You balance those risks, and you understand what the risks are, and you decide to move forward. Great. If the client or venue isn't as big or backed by attorneys, and then we can work on, negotiating those things out, where they're they might ask you to name them as additional insured. What that does is, if you're naming the venue as additional insured, the museum as additional insured on your policy, that means if someone ever gets hurt near that exhibit or near where your work was, and there's a finger pointing battle between your insurance or your attorney, and then the venue's insurance and their attorney, and their finger pointing, if you name them as additional insured, your policy is going to pick it up and that finger pointing goes away. So really, you're giving up that right to say, no, actually, we think it's the landlord, or we think it's the venue. And but you're going to have different clients at different venues. So at the end of the day, we'll tell you, hey, they're pushing all the liability down to you. And then you, at that point, you can negotiate with them, or you can say, you know what, this is actually a good opportunity. I want to go ahead with it. Or if it's not worth it to take on liability, you might decide to walk away with it. That's just from an insurance standpoint. But Sam, I'm sure you want to touch on that as well.
Yeah, I think I'm mostly in agreement here because when it comes down to like that type of really broad language, there's usually one of two things happening. One is just that they don't realize it's that broad and it's just the language they've had in their contract for however long. Or the other one is kind of what you said, Christian, where there's an attorney or a legal department that is not sort of aligned with your point person that you're dealing with, and they don't have like what the specifics are and what the limits should be, and they just threw in everything in the kitchen sink into that provision, and it's just detached from the reality of the contract. And so that's a common thing where, who you're working with is not on the same page with their legal team. And so a lot of the time you kind of have to cut through all that and say, look, like I kind of can see what's happening here, and I need you to speak to your legal team and help them understand that this is not appropriate for me. Or, worst case is your attorney has to talk to their attorney and then it takes longer and the calls are expensive and all of that. So that's usually what comes up there. And I think a lot of the time what I find myself advising on for clients is we will have a call and they will just lay it out very like matter of fact and frankly for me. And I say, great, now go do that for them. Because if you can give someone the why behind why that provision doesn't work for you, rather than trying to negotiate the actual legal language and the legalese, you're more likely to get to a resolution than just going back and forth with legal on the language when there's actually no like objective and why behind it. So I'm always a fan of like just give it to people straight, tell them why that doesn't work for you, and that should hopefully help you resolve that with a provision that works for both.
Awesome. Okay, we're going to pause our Q&A here. I want to let everybody know that Sam and Christian have generously offered to stick around for like 15 extra minutes so we can bring our webinar formally to a close. Those people who have a hard 11 a.m. stop can exit, and then we'll have a few more minutes to dive into some of these other questions. But just to sort of tie a bow around this session, Laura, if we can get the slides back. So thank you so much again to our panelists. And thank you to Jasmine and to Laura for your help with the Zoom. We're going to drop the contact info for our panelists into the chat so that if you have specific questions or you'd like to engage their services, you can reach them that way. And then independent museum professionals, you can find us online at indiemuseumpros.com. You can find our upcoming events. You can find recordings of past webinars, and you'll also find a button that says join us where you can sign up for our newsletter and our listserv so that you continue to be in the loop on events such as this one. And then you'll also find us on Instagram and LinkedIn if you like to stay in touch that way. If you're looking for more ways to get involved with IMP, we welcome your involvement. You can volunteer, you can send us your programming ideas, you can join our listserv, which is a very active and supportive community of independent professionals, and you can attend an in-person meetup. So Laura, if you don't mind going to the next slide. Like I said, you can visit the website, click join us to sign up for the mailing list. And then coming up on the IMP calendar, we have an IMPs Connect session in April where you will get a chance to know your fellow IMPs and have a little April Fool's fun. So you can register at the link in the chat to sign up for that virtual event. And then we also have we'll have a meetup coming in May at 8 a.m. for those of you who will be attending that conference in Philadelphia. So again, make sure you're signed up for the mailing list to get the details on that meetup. And then finally, we have a very short survey that we would love for you to complete because it gives us very valuable feedback on our programming that we offer. So there's a link in the chat. And if you wouldn't mind taking a couple minutes now to complete that survey, that's all it will take you. And then we'll just roll right into our extended Q&A with Sam and Christian. So thank you again, Sam and Christian, for agreeing to do that, because I know we got a lot of questions. We'll just give folks a couple minutes to do the survey. Sam and Christian can get a drink of water. They're still here, right?
Yeah.
Okay.
I would just go ahead with the questions, Jenny.
Okay. Just didn't want to distract people while they're giving their valuable, thoughtful feedback on our survey.
No, they never do the surveys right away. They never do them right away. We'll send them email to remind them.
Okay. All right. Okay, so moving on to the questions. If I put together a team of people to do a proposal for a project, and some of them are subs to me, do I need to note that in the proposal or contract, even if we are approaching the project as one team?
Few different answers to that. So I would go back to, depending on which state you're in, if you do approach a relationship like that and you characterize all the contractors as part of your team, you could be in danger of employment classification, inadvertent employment classification. So certainly something to be aware of depending on which state you're in. And then beyond that, what I would say is that every contract should have some language in it about independent contractor status, both that you are a contractor to whoever you're working with, and then also covering whether or not you have subcontractors underneath you, because If it's silent, that leaves an area that later maybe who you're contracting with can say, well, I didn't approve that you work with subcontractors, or we feel like your subcontractors didn't have the right confidentiality, or whatever sort of thing can come up. Because one of the biggest issues that you just need to be aware of with contracts, if they're silent on something, that can create a recipe for disaster. So I would say that you should certainly have language in your contract that says you may have subcontractors, and that's totally up to you and not on their plate, and they don't get to approve that, like I mentioned during my slides. Because certainly if you have a situation where, let's say, one of those subcontractors uses material that they shouldn't have, and then your end client finds out about it, that's going to be a big mess. So it's just important to make sure that that's clear between the parties for sure, and that you have some liability protection there with your subs for sure.
Yeah, that was more of a legal question, so no insurance input needed on that. I think you're on mute, Jenny.
Thank you. Bart has a question about pay if paid and pay when paid. Is there a national law around that kind of wording in a contract?
It's not that there's a sort of national law or like a federal law, but there is state by state rules when it comes to these types of things. And typically, pay if paid is pretty frowned upon. Like, for instance, in California, that's not going to fly. You can't have a contract that says you will pay if you're paid. You can have a contract that says you will pay when you're paid, and that's typically a little bit more favorable when it comes to how the law applies to that. But generally speaking, pay if paid is something you should stay away from. And it has sort of equitable underpinnings to that if you think about it, where that's sort of like, I kind of hate to use this terminology sometimes because it seems very callous, but like that's on their side of the fence. How they get paid for their work that ultimately results in you getting paid is their business, their side of the fence, and they should be able to pay whoever they contract with to pay. Just like if you contract with someone, or like if you have credit card debt, it's your responsibility to have money to pay that. So I would say that like pay if paid is just generally something to stay away from. And it's worse usually for you as a contractor getting paid, because then they'll use the excuse that they didn't get paid this way or someone didn't pay this, so they can't pay you. And so even pay when paid, even though it's legally typically permitted, I would stay away from that as well. Like if you provide services or you provide products, you should be paid, period. It shouldn't relate to anything on their end about them getting paid.
Okay. A question about intellectual property. What about photos of a public venue that may have random people in it, such as a museum opening? What are the photographer's property / IP rights, even if it's a non-professional snapshot?
Yeah, so that'll go back to what I mentioned before, where people might show up in an image. You can take that image and you can use it on your desktop and on your phone and like personally all you want. It's more so if you're then going to publish that photo publicly, that's when these rights start to come into play. And with a situation like that, where let's say you got a video or a photo of a full room, the best thing to do is before anybody comes to whatever that event is, they sign an image and likeness release, maybe as part of their ticket purchase, or even at the door. People don't typically like signing something legal at the door, but it would work. Alternatively, this is not as strong, but it can hold up depending on the circumstances. If you have public placards sort of put up around the space that say photography and videography are happening, and by staying in this space, you are consenting to being photographed or showing up in a video. And so that public placard is sort of like a secondary way to have that kind of image and likeness release. It's not as strong because people might not have seen the public placard. They might not, thought that it applied to them or that it wasn't real or whatever. So having somebody sign something is the best way to handle that. But that public placard, if there's enough of them and they're big enough and they're conspicuous enough, that might be enough to say, well, you waived it by staying in this place where we were doing video or photos.
I'll just add something to that from an insurance standpoint. If you, to go along with Sam said, if you put something on your website as well, that opens you up to being sued. I had a client, I've been in commercial insurance 12 years. Early in my career, I had a client, they were a jewelry store, and they posted a picture on their website of Sandra Bullock wearing one of their watches that they sell without getting Sandra Bullock's approval. Which you should know common sense not to do that, but I guess they didn't know. They got sued and ended up being, $1 million lawsuit. Under the general liability coverage, there's what's called personal and advertising injury coverage. And under that, you do have coverage under the general liability as long as it includes personal and advertising injury that would respond to pay for defense and settlement costs if that were to happen.
All right. Next question. If possible, could you touch on key persons insurance and buy-sell agreement?
Yeah. So key persons insurance, meaning like by that, do you mean someone that's going to take over for the business? What do you mean specifically by that?
I'm checking to see who asked the question. Elliot Gavin, are you still present? Okay, it looks like Elliot had to jump off.
Okay.
So maybe we'll just go to the next question. Sorry, Elliot.
Okay.
Okay. I've had situations where I wasn't intending to transport museum objects, so it wasn't part of the original contract, but then I ended up doing so. Should I have done an addendum before doing that?
I would say yes. I would definitely say have some type of addendum, amendment, and just to kind of add a little bit of legal to that. So typically, if you amend a contract, you have to have some type of like basis to it, some type of consideration to make it a valid amendment. And in that particular situation, presumably like they're probably going to pay more to handle the shipping, and then in return, you're handling the shipping. So there is that proper underlying basis to make that a valid amendment. And so, yeah, I would say just going back to like everything should be clear in contract and it should be spelled out and dialed in. Definitely make sure that if you're going to change anything about your contractual arrangement, practically speaking, like this example of then having to transport, that it's part of your contract in some way, shape, or form, because otherwise it's completely outside of that contract and can kind of leave you in the lurch if you don't.
And I'll just Sam touched on the contract real quick on the insurance side. Check with your insurance broker to see if your coverage includes in transit, if an exhibit or some type of property is moving. Sometimes, depending on the policy you have, it may include in transit coverage from the time it leaves your possession, your warehouse, your location until the time it gets received by the end user, whoever's buying it, whoever's getting it. And at that point, the coverage stops. But not all policies include in transit. So once you understand what your exposure is on your contract, check with your broker to see if you have in transit coverage.
Okay, here's an interesting question. Does errors and omissions insurance cover the use of AI?
So AI is, obviously a new emerging risk for society, for insurance industry. I think, I mean, I'll speculate. Is it that you're saying if you use AI to give advice and then it comes back kind of thing? Is that what you mean by that question?
If this was your question, go ahead and chime in. Using AI as part of the design process.
Yeah. So anything, and Sam will speak more on this, but anything that you could, if you get sued for design services, professional services because of an error mission, and your business is named in the lawsuit, the E&O that triggers E&O coverage, the E&O will cover that. As of right now, most carriers are not excluding AI related services or using AI. That may change as AI continues to develop. They may say, "Oh, we're not going to cover if you're using AI. You're on your own." But as of right now, they're not excluding that. So that means it's currently covered from an insurance standpoint. But I'm sure Sam has more from a legal standpoint on that.
Yeah, I mean, I think this is one of those things that where generally speaking, the law is slow to catch up, and especially here. So I would say that like my instinct would be that it's going to be covered because it's still just an error or an omission within your responsibilities. I think this is one of those situations where it's super important to look at your policy with a fine tooth comb when you get it and see if there is any type of call out, any type of specific mention of AI. This is one of those things that until we have some type of like consistent guidance under the law, which I don't expect us to have anytime soon, given just the different approaches to this, that it's probably going to be like an organization by organization preference, meaning that some insurers might exclude it, some might not, some people might handle it differently. So it's going to be very important just to look through your policy, your agreement, anything that might mention it to see how it's treated.
Yeah, and as of right now, we really haven't been seeing that. Like after COVID hit, we started seeing pandemic related exclusions on policies. We haven't seen the AI exclusions yet, but like Sam said, it's constantly evolving. So that could happen at any point. If there's a big lawsuit or something, that could change the industry and they could start excluding that. But as of right now, they're not excluding it.
All right. Can you give an example for good language for a force majeure clause to account for flight delays, missed workdays due to snowstorms, for example?
I can, but that is not something that I'm going to be able to rattle off the top of my head in this. And it's something that even if I said all the words, you wouldn't be able to write them down correctly anyway, because it's all legalese. So we do free consultations if that's something that you need. Happy to help with that. But generally, a force majeure provision is going to be a paragraph long and it's going to have, 5 or 6 sentences in it. And so it typically also should be kind of crafted for specifically what you're doing. So yes, but it's not something that me rattling off verbally will be helpful for you at the moment.
Okay. Sam's contact info, as a reminder, is up there in the chat if you want to grab it. Okay. Would a fine art policy be recommended in addition to professional liability and general liability if you handle high value art objects in your work?
Yes, I know Blair is going to do a whole presentation on this. She specializes in fine arts. We do fine arts as well, but like that's her main specialty, and she does a lot of high value things. And I don't know when she's presenting to you guys, but that should be in the near future. But yes, if you have high value artwork, and you don't have cover, like the thing is a standard commercial policy, they're going to have contents coverage or business personal property coverage, but that's going to exclude fine art. So that means you have to cover that gap. So you can go back to your current, if you have a business owner's policy, you have a commercial property policy, say, what will be the cost to add fine art at this limit? If it's $100,000 worth of fine art, whatever it is, you can go to your broker and say, can you run me the cost of adding this fine arts coverage? And it can be either added onto your current policy if you have a property or business owner's policy, or you could do like a separate fine arts policy. But just know if you don't have coverage for that and something goes wrong, theft, the artwork's stolen, fire, internal water damage, pipe bursts and destroys it via water, and you don't have coverage for it, you're out of luck. So you definitely want to make sure you're covering that gap and talking to your broker to make sure that that gap's filled. You're on mute, Jenny.
Yep. Thank you. Okay, one more question if that's all right. Okay, with a home office covered under homeowner's insurance, does the insurance cover potential liabilities for a sole propriety type of business?
So if I understand the question correctly, you have a homeowner's policy that's going to have personal liability on it. And that's going to cover, personal liability if someone were to come to your home and slip, trip, and fall, get hurt, that it would cover that. But it's not going to cover any commercial, unless you have a additional endorsement policy change add-on where you add a little bit of commercial coverage on. But most homeowners policies aren't going to include that. So if you want to cover anything that's business related, most homeowners policies are going to exclude that. So if there's a liability, an injury or property damage that were to be caused by your business, either at your home office or away from your home office, you would need your own commercial general liability policy that's separate from the homeowner's policy.
Yeah, I would just add to that almost always those policies are going to exclude anything that's commercial unless there is some type of rider for that. When I say the contract should be super clear and specific, some of the most clear and specific are insurance policies for sure, and they're probably going to exclude a lot of that kind of thing.
Okay, thank you both so much for being here today, for staying over to answer additional questions. We really appreciate it. Jennifer, thanks for hosting. Laura and Jasmine, thank you for facilitating the Zoom. Anything else you guys want to add before we sign off?
Thanks for having us. Appreciate it.
Yeah, thanks for having us.
Sam, if you want to share your force majeure language, we do send a thank you note, and we can, if you're comfortable, you don't feel comfortable, don't do it, but we can put it into the thank you note with as many warnings and disavowals as you want to put on it.
Sure. Yeah, I'll send over one that's just kind of a boilerplate one, but certainly please include the disclaimer from my slide with it, and then that way we can provide it.
Okay, great. Thank you.
Yeah.
Thank you all. Okay.
Bye, guys.
Bye.